Hello, everyone, and welcome to On Trial, the podcast where we explore how to build your practice, trial tactics, and what can make or break your case. We're your hosts. I'm Matt Heimlich.
And I'm John Risvold.
And today we are coming to you from the midst of the coronavirus social isolation universe. Both John and I have been working from home for about, how long has it been now, John?
I've been doing this since the 13th of March. This is week 3 or 4. I don't know. Time is kind of a flat circle right now,
It certainly
right?
is. It certainly is. And I'm at about the same time frame. I've been home for about 3 weeks. And I wanted to ask you how you've been adjusting to working from home all this time. I know you usually are in the office, as am I. And what kinds of things are you doing to keep yourself productive and up to date while being remote?
So the interesting thing is, like you, I spend a lot of time in court. I have a lot of depositions. None of that's going on right now because the courts are closed. And a lot of the depositions have been continued because people don't know how to use technology as well as we would like, probably, so that we can do them remotely by phone or video. So a lot of the time has been spent just kind of sharpening my tools, reading a lot, getting on a lot of webcasts like this and learning from experts, but also just kind of digging into my cases and seeing where I can make them better and how I can better help the clients. That's been a lot of my work. The life side of it has been interesting because, like you, I've got kids. So keeping the kids sane, keeping myself sane, trying to get outside when I can get fresh air, go for a run, that kind of stuff. Those have been the sort of things I've been trying to do, but cabin fever is a real thing.
Oh, it certainly is. I'm certainly feeling it over here. Kind of on my end, what I've been doing a lot is catching up with clients. I've been doing a lot of Zoom calls, doing a lot of phone calls, checking in, seeing how they're doing, getting updates, giving them updates about progress on your case. I've also been doing a lot of legal research, actually. Yesterday in particular, I dug into 2 issues having to do with damages on a larger case that's going to trial later this year. It's a tough case. It's a catastrophic, permanent type injury case. And I really wanted to do my homework and dig in on what we needed to prove, what the proofs are, what the case law says. And I spent I'd say at least half the day yesterday doing that, just really getting deep into the case law. And it's something that if I'm at the office with the phone ringing all the time and people coming in my office asking questions, just the natural distractions of being in that kind of environment, it's really difficult for me to do. But even with, the kids being home like you have, I've been still trying to find the time and the space to kind of do those deeper projects that require a little bit more thought, a little bit more time, and just kind of setting aside a couple hours in a block to do something, which, as you know, in an office environment isn't always something that you can do.
No, that's really hard to do. It's nice to be able to have a little bit more time. And you're right. Like, this is a really good time if you have a trial coming up. I know my fall is jam-packed with trials. I've got 2 in July, 1 in August, 1 September, 1 October. It's a really good time to figure out all your motions in limine. It's a really good time to figure out, what kind of voir dire works for what kind of case. Practice it. Practice your open. Do your jury instructions. That kind of stuff that really, sharpens your toolkit and makes it so much easier and less stressful when you get to trial. I mean, I'm the kind of person who probably, like a lot of lawyers, I do a lot of my motions in limine or a lot of my jury instructions or anything like 3 weeks before trial or, 2 weeks before trial, sometimes depending on how busy I am. But with all this time that's been freed up because the courts are closed, it's a really good time to sort of get ahead of the 8 ball there and really make the defense work a lot harder.
And that's a huge advantage when you have all of those things done ahead of time, and then that frees your mind up and your time up to focus on the strategic things and the other items and pieces of evidence that you want to get into play, and really work on your cross, on your direct, and work on your story to present your case in the best light, and not having to worry about all that other stuff. That
it gives you time to perfect your story, because what we're really doing when we're talking to a jury is we got to tell them a story about something they know nothing about and we know everything about. We're living our cases and we're dealing with our clients and working with our clients and trying to help them, but they don't know us and they don't know our clients. They don't know anything about the story, and we have to give it to them in a way that, especially now where everyone wants, snackable, bite-sized sort of content, and they want everything in its simplest form. We have to take really, really complex issues and really break them down and distill them into ways that a jury is really going to understand. And this gives you a lot of time to do that. So I think that if we can stay focused and stay sort of optimistic and positive in a time where it's really hard to do that, we will come out of this with a great advantage for our clients in our cases.
I think that's absolutely the right attitude. And one of the things that, making a sharp turn here, one of the things that we wanted to talk about today is both John and I share a similar background in the fact that we both used to do defense work, and then over time we ended up jumping the fence and doing plaintiff's injury cases. And I wanted to talk about that. We wanted to talk about why we both chose to make that jump, and talk about, the different things that we've learned from being on both sides of the fence as opposed to, just being on one side or the other. So John, how long did you work as an attorney at a defense firm before you ended up jumping over to the plaintiff side?
Yeah, so I was on the defense side for a little more than 5 years, primarily doing mesothelioma, toxic tort, and asbestos defense. I also did a little bit of some general civil defense, med mal defense, insurance defense, kind of ran the gamut, but the majority of my practice was toxic tort, asbestos cases. And I did that for, about 5.5 years or so. And it was enough time to realize it wasn't what I wanted to do, but I thought that it was a really great experience, and it offered me, a lot of opportunity to, I think, really accelerate my career and get a lot of experience that people that are my contemporaries didn't have. I mean, I've taken thousands of depositions because of how many there are in an asbestos case. So things like that have been really helpful.
Outside of the depositions, what kind of other things did you pick up as far as how insurance companies and self-insureds, how they view and evaluate cases involving injuries?
So the biggest thing was how formulaic it can be with certain types of injuries and the limitations on activities of daily living and things like that. Every time you have a case, you take a deposition, or anything significant happens in the case, we would do a report, and then we would do one every 90 days, usually. Sometimes carriers wanted us to do them every 60 days. And we would write a report of, here's what's going on in the case. Here's what we think of it. Here's what our valuation is, or what we think it's worth. But the thing that stood out to me, and I think the thing that's helped me the most as a plaintiff's lawyer, is understanding that there's a huge section in a lot of these reports that is basically, is the plaintiff somebody that a jury would like, trust, rely on, care about, want to help? It's not exactly framed that way, but that's what they're asking. And if you can make sure that your clients come across as the real people that they are, genuine, trustworthy, believable people that they are, I think that carries a lot of weight when a defense lawyer is talking to the insurance company and explaining what the exposure is or what the potential risk is to that insurance company.
That is such an important point. When I'm prepping clients for depositions, I always tell them that, I've done focus groups before, you've done focus groups before. And the things that really matter to people are, do they trust you and do they like you? If you can have both those things, then you're set. The things that you say, they're not going to be perfect. You're not an attorney. You're not an accident reconstructionist. You're not a doctor. You're not going to have all the details perfect. Your memory's going to be a little bit fuzzy. But if they trust you, and they like you, then you're in great shape.
Yeah.
And if they don't trust you, if you're inconsistent, if you say things that can't necessarily be backed up, then there's a problem, because then it doesn't matter what you say, because the jury's skeptical of you anyway. But I think you've really hit the nail on the head. If your client presents themselves well, if they present themselves as an honest and trustworthy person, then that puts you miles ahead when it comes to all these injury cases, really.
Yeah, you can't get credibility back, right? I mean,
right.
Perfection is not the game. The game is, are you telling the truth? Are you believable? And do you have credibility? And I think, that's why we work so hard to find where defense experts might be not representing the records or the truth correctly. I'm not going to call them liars, but where they're paid to sort of spin or stretch the truth sometimes is, that credibility can be really undermined with any expert on either side, if they're not really doing their job correctly or fairly.
Yeah, no, absolutely. My background's similar in a way, but a little bit different. I spent about 8 years on the defense side of things, but the primary focus of my practice was defending nursing homes and assisted living facilities. And I did that for about 8 years before jumping over to the plaintiff side. And in nursing home cases, they're kind of a unique niche within both personal injury and even within medical malpractice. A lot of the plaintiffs in the case, we were talking about credibility, aren't the injured person. It's usually a representative there to state if they've passed on, or a lot of times they're incompetent to give testimony, so it's a family member. So a lot of times when on the defense, I would be deposing the plaintiff, it wouldn't be the actual injured party. So that the credibility thing kind of goes out the window in a way, because you're not talking to the person who actually was hurt. And in a lot of these nursing home cases, it's basically presumed that the allegations in the case are true to a large extent, because there's no one out there to refute it except for other staff members. And obviously there's a bias there that they're going to try to put things in the light most favorable to them. And you have the plaintiff, who's usually an elderly person, sometimes has capacity issues and isn't able to testify on their own behalf. And obviously that's a more sympathetic person. So
Right.
You're dealing, the nursing home defense thing, you're starting basically fighting with one hand behind your back. It's a very interesting practice. It was interesting and difficult. I did enjoy it in some ways. Some of the people, the nursing home industry, obviously there's a stigma associated with it, and there are obvious reasons why there's a negative stigma associated with it. And we can get into that in depth at another time. But I did enjoy working with some of the people over there. I had a great boss over there who let me work up cases from at a pretty early on, from from the time they came in the office through trial. So I got a lot of great experience, like you said, a lot of depositions, working with experts, retaining experts, deposing and cross-examining experts. And nursing home cases don't go to trial as much, so that was one thing that I would say I wish I'd gotten more of on the defense side, was more trial experience. But that's just kind of the nature of that industry. There's a lot of incentives for cases to settle, so trials were kind of few and far between as far as actually taking them to verdict. But a lot other, basically beyond trial, I got a lot of great experience from all aspects of the case.
Yeah. So what was it that made you want to jump sides and come over to the plaintiff side?
I really always wanted to go on the plaintiff side. When I was in law school, I clerked at a personal injury firm. My interest has always been kind of where law and medicine come together. Even when I was in college, before I knew I wanted to be a lawyer, I was interested in those things. My college admissions paper was about a public policy issue, about the legal aspects of a medical issue. I actually entered college as a pre-med. That didn't last long at all. Found out pretty quickly I wasn't cut out for that. So I went down the political science law route. And I always kind of knew I wanted to represent injured people. That's one of those things that it's weird that this job is so strange. It's I think it's a unique profession, even within the law. And it requires a certain personality and a certain kind of devotion to what you're doing. Not that other attorneys aren't devoted. A lot of them are extremely devoted to what they do. But it's dealing with exclusively with people who've been hurt, dealing with deaths, dealing with people who've been catastrophically injured. It's a lot. It's taxing, but it's something that if you feel, it's also very rewarding at the same time.
Yeah, I agree.
It's one of those things. It takes a lot out of you. It's a very intense profession, but I think if you feel compelled to get into it, then it's just something that you ultimately are going to get into, whether it's 2 years out of school, right out of school, or in my case, unfortunately, 8 years out of school.
Right. Yeah. Well, same here. I knew I wanted to try cases just because I knew that was, what fired me up and got me out of bed. Right. But what you're talking about is exactly right. The difference between, the great personal injury lawyers that I've had the chance to observe or spend time around or talk with, that's the difference maker, right? Is they're true believers. They really, really believe in what they're doing and that it makes a difference in society, that it makes a difference for their clients. The flip side of that is also what you're talking about. There's a lot of absorbed trauma, right? There's a lot of weight that we carry on our shoulders when we're dealing with the families of people who've been wrongfully killed, essentially, when we deal with a wrongful death case, or people that have had their lives completely changed by a catastrophic injury, especially younger clients who have their whole lives ahead of them and their whole lives have been upended. I'm thinking of some of my clients who are in their 20s or 30s and have traumatic brain injuries. And they're going to live for another 30 or 40 years, but they're not going to be the same person. Right. And so there's a lot of that you have to take on your shoulders. And I think that is a big motivator for me. Obviously it's a big motivator for you, but you're right. You run the risk of burnout. You run the risk of sort of overloading yourself with some of that external absorbed trauma.
When it comes to, once you've made the decision to go from the defense side to the plaintiff side, what things did you do to kind of start and build your practice? Because obviously the clients are totally different. It's a whole different business model. How did you kind of address and meet that challenge?
First of all, I let every single person I've ever met under the sun know that I help injured people. And I worked really hard to craft, a message, an elevator pitch, if you will, to tell people when I meet them, or to send out emails to everybody. I built an email list from all my LinkedIn contacts, and I send them all an email that said, hey, we met through such and such, the Chicago Bar Association or Illinois Bar, or whatever it is. And I wanted to let you know, I help injured people now. And if I can ever be of any assistance to you in any way, let me know. And truly, that is how I got some of my first cases. I mean, some of the first cases that I was able to take and bring on were just because I was grinding and hustling and trying to meet as many people and build as many contacts as I could. And I've found that the easiest way for me to help people is also by giving. If I'm able to, connect people with a lawyer that they need, they remember that. And so when they inevitably need a lawyer like me, thankfully they've remembered that. And that's been how a lot of it has worked for me.
Absolutely. You were talking about that elevator pitch. I know one of the things that you and I share is we're about the same age, and we're certain we have the same approximate experience level. And the weird thing about our business too is that all attorneys who do what we do basically charge the same fees. So you're charging the same fees as a guy who's been practicing for 35 years and has, $100 million of verdict in, back in their bank account. So what do you do to kind of differentiate yourself and explain why you would be the best lawyer for a given person, even in like catastrophic, big damages injury cases?
So I think that the advantage that I have, is the advantage that you have as well, is that I'm not a solo practitioner. I'm working with an established firm with established lawyers who have been practicing for 25, 35 years. And so I've got a deep bench in that sense, right? The other thing that I can promise clients is, because I'm a younger guy and because I'm, I grew up with all this technology and I grew up so connected, I'm always available. If you need me on a Sunday night, you have my cell phone number if you're my client. I'm going to give you personal attention, and I'm going to make sure that your case is worked correctly and that every stone is turned and every bit of investigating that needs to be done is done. I can't promise that I'm the best lawyer in Chicago or Illinois or the world, but I can tell you that I'm going to work harder than anybody else you're going to find, or at least that's the promise I'm going to make, is I'm going to work as hard as I possibly can to make sure that you get the best result you can.
I think you've really hit the nail on the head there, because that's kind of the same way I've been approaching this, especially with, when you're presented with an injury that is, a profound catastrophic injury, and the client maybe is thinking in the back of their head, okay, why don't I go to one of the big name firms downtown? You and I both practice in the Chicago suburbs. there's a huge majority of the injury firms are based in downtown Chicago, and
Right.
they think, okay, maybe I should go to one of the guys on the billboards or that I see on TV. Why you? And I think you really you explained it perfectly. It's about personalized attention. It's about attention to detail. It's about making them a priority.
Yeah.
You can offer that in ways that other firms might be able to say that they can't, but they're really not going to, because if you have 100, big dollar injury cases and, this person walking the door is case 101, that's really not going to be a priority. But if you have a smaller docket, you give that person more personalized attention. You can tell them about how you're going to stay in communication with them, give them updates on the case. And then like the most important thing you said is follow through.
Yeah.
We have all this technology, we're now, with everything going on in the world right now, more open to it, and it's becoming more prevalent, which is great because a lot of the people that are clients, we have some clients that are unsophisticated with technology. Everyone's basically has to become more sophisticated with technology now to stay in contact with everybody. So, I have older clients that don't like to use email. They're getting emails now. Yep. I have clients who, they don't have Zoom. Now we have Zoom, like you and I are doing right now, to stay in communication, because there's nothing like, face to face, even if it's on a video. It's so much different than a phone call.
I agree.
No substitution for an in-person meeting, but this is basically the best we can do under the circumstances, and people understand that, and they're starting to get evolving with the technology and making it a part of our practice and a part of our clients' lives. And it really does. It really has a great effect in helping us communicate with our clients and making sure that we know that they know that they're on our minds and that we're doing the best for them.
Yeah, I agree. One of the best pieces of advice I've ever received is get to know who your clients are as people. Go have dinner with them, invite them into your home if you can, but meet with them outside of the context of I'm your lawyer. Meet with them as you would meet with a friend and get to know who they actually are. It's funny you talk about, file 101 or 102. On the defense side, every file had a number. This is file 5047, whatever it is, right? I don't have file numbers on the plaintiff side. I have clients with names and they're actual people. Like,
same here.
I don't have file numbers. And, sometimes I'll get requests from the defense like, well, can you tell me what your file number is? No, I can tell you my client's name is Jane Smith. And Jane Smith has my cell phone number, and Jane Smith and I know the names of her kids, and I know who her husband is and who her parents are. And I know what she enjoys for a living. And this is an actual person. It's not a file number. And I think that is a real big differentiator for any trial attorney, any plaintiff's lawyer, is just get to know your clients, know who they are as people. Don't treat them as a file number. Don't treat them as collateral, right? They're actual people who have suffered, serious injuries, serious consequences because of somebody else's negligence.
Right. I think another thing that can kind of help, people like you and I and other attorneys who are about our experience level differentiating themselves is kind of subspecializing within the field of injury law. I know all of us have different experiences. My experience has mostly been in the nursing home realm. I have a ton of experience with that industry, and I know, the regulations, I know the statutes, I know the standards. And then some people like yourself, you have experience in other areas of law, probably more so than I do, or a lot of other attorneys. Tell us a little bit about that.
Yeah, so some of my specialties, my firm has a toxic tort specialty, but what I've started to specialize in personally is brain injury work. It's really fascinating to me how the brain works. It's emerging science. It's emerging medicine. And there are not a lot of attorneys in our area or even in the country that are doing, catastrophic traumatic brain injury work at a really, really high level. And I think that it's going to be, as the science develops and as the medicine develops and we understand the brain more, I think it's going to be a huge area of opportunity for people our age. And so that's something that I've worked really hard to try to understand and try to sort of niche down into. In the same way that you do with medical malpractice, complex medical malpractice or complex nursing home cases, which are very similar to med mal cases. I think it's really important. You're right. It's really important to find a subspecialty but do it in a way that you're passionate about, right? Don't just do it because you think it might make you money or it might make you stand out. If you don't like it, it's not going to make you money. It's not going to make you stand out because you're not going to be passionate and you're not going to care.
You're absolutely right. It needs to come from a place of genuine intellectual curiosity,
Yeah.
and a passion for helping people. I mean, that's what the nursing home stuff, I kind of was brought into that. I needed a job. I got a job at a defense firm, but then ultimately over time, you get to know this industry, you get to know the people involved, and you see things and you become, I became, very passionate about protecting the rights of the elderly, about making sure that nursing homes operate in a fashion that respects the rights of residents, about making sure that standards of care are adhered to. And, the medicine has always been interesting to me. Like I was talking about before, I've always been kind of interested at the interplay between medicine and the way doctors and hospitals operate and how that intersects with the law. And that really became kind of my entry point into medical malpractice and nursing home work. And it's something I genuinely am curious about. I read about these things all the time. I try to stay updated on the cases, on the medicine too. And I'm sure you've done the same thing with traumatic brain injuries, which, as you said, is an evolving science. So tell us a little bit about how you keep up to date with those things.
So the biggest game changer for me was finding groups of people, that basically mastermind groups that I could connect with and learn from. So one of them has been a listserv that's run by Nick Rowley, who's a lawyer in California who does a lot of traumatic brain injury work. It's called Trial by Human. That's been a really big boon to my practice and my ability to learn. The other one was I went to a conference 2 years ago now in San Diego called the TBI Med Legal Conference, where they brought together 100 different doctors and 100 different lawyers. It was a 3-day conference, and all they talked about was how to help people with traumatic brain injuries, how to work these cases, who the experts are that you need, who is working on emerging science, what it is, what the best technologies are for brain imaging or everything under the sun, and getting connected to that community. It is primarily, lawyers on the West Coast, but there were lawyers from all over the country that I met, and getting connected to that community and getting plugged in has been an incredible resource, because anytime I need an expert, anytime I need a new, article or anything, it's being shared all the time. And that's been a really, really great community for me to be plugged into, just so I can continue to learn and continue to grow and continue to help people. How about you?
Yeah, that's one thing I found fascinating about the differences between the plaintiff side and the defense side is the level of information sharing on the plaintiff side is unbelievable. Yeah. Between listservs and, bar associations and groups and like even subgroups, like you were just talking about, the amount and level of information sharing is just unbelievable. I don't think there's anything comparable on the defense side that I'm aware of, as far as people sharing everything from opinions on experts to discovery to depositions to experts. It's an unbelievable resource that we have in our colleagues and friends, and it's truly amazing. And the kind of a rising tide lifts all boats ethos among the plaintiffs bar is something I find I certainly didn't see on the defense side, and I find it incredible that seems to be in the minds of most of the people that you come across in this business. It's truly amazing, and I think it's unique to the plaintiffs bar.
Yeah, I agree. It's something that I did not expect when I came from the defense side to the plaintiff side. Everybody that I interacted with on the defense side, my colleagues when I was a defense lawyer, had sort of an image of plaintiffs lawyers as this cutthroat group, hyper competitive, competing for the best cases and competing for the biggest verdicts and everything else. And while there is some of that, I mean, everybody wants to be able to help people and handle complex cases and do incredible work. What I found is that every single plaintiff's lawyer that I've reached out to for advice goes out of their way to help me. It's an incredible community. And you're right, it is that rising tide lifts all boats mentality. I see it on listservs all the time where, such and such got this incredible verdict, and there is no, derision or, anything negative. It's all, that's incredible. Congratulations. Tell us how you did it. Teach us what you did. Give me a recap of what worked for you, who were your experts, who were, your star witnesses. There's a lot of collaboration on this side, even though it is a competitive industry. And even though it is, a competitive group of people, I think most plaintiffs lawyers are very competitive in that we hate to lose more than we like to win, but we're not doing it at each other's expense. We're really, rowing the boat in the same direction. And I think that's really, really cool to see. And it's an incredible community.
Yeah. And the most amazing thing about that is when you ask, well, how did you do that? What worked for you? They will actually tell you.
Yeah.
It's unbelievable. It doesn't always happen that way. And that is one thing that I've been consistently shocked by since I've made the transition, is how open and willing to share everyone on this side of the aisle seems to be with each other. It's a really amazing community, and I'm really happy to be a part of it.
Before we go, we're going to do something we plan to do every podcast episode. Matt, just give me sort of your 30-second trial tip.
Well, this first one's not exactly a trial tip. It's a mediation case resolution tip. I know mediating cases has become extraordinarily prevalent. I always think of it as a good option to try to attempt resolution. And not everyone does this, but some mediators like to have the plaintiffs and the defendants give opening statements in a mediation to kind of lay out their case. And I am totally against this practice. To me, the whole idea of a mediation is to bring two parties together, to rise above their differences, and to try to achieve a resolution. And by giving an opening statement that generally is going to point out where the parties differ on the facts and the damages and the injuries, it to me only serves to drive the parties apart. And it kind of undermines the whole process of mediation for me. So I've always tried to avoid having an opening statement. The one time where I was forced to, the mediation fell apart. I don't think that's a coincidence. So my advice to any attorneys out there is, when you're mediating a case and the prospect of an opening statement is brought up, just say no. It doesn't serve any purpose. It's going to undermine the purpose of the mediation. And in my opinion, it's not going to lead to any resolution, let alone a better resolution for your client.
Yeah, I think that's a great tip. I really agree. I don't like the opening statement either. It feels forced. It doesn't seem to help your client at all. So that's a fantastic tip. My quick tip is, I think, goes well with life in the time of coronavirus. I have become an iPad sort of disciple recently. I just got my first iPad. I love it. And what I really love and what I've been using is Transcript Pad. It's an app. It's a little bit expensive, but I can load all my trial transcripts onto it, all of my depositions onto it, carry them everywhere I go, and I can mark them up. I can cut them up. I can find key pieces of testimony and flag them so that I can really quickly use them if I'm, writing demand letters, writing mediation statements, drafting motions in limine, and I want to exclude certain testimony, or preparing for trial, getting ready for a cross-examination or a direct. I have it all at my fingertips, all in one place. I'm a huge, huge fan of this app. I think it's so useful, and it's incredibly easy and user-friendly. Like I said, it's a little expensive, but I think it pays for itself. So that's my quick tip of survival in the life of an attorney during coronavirus, right? Is use technology where you can to make your practice easier.
Absolutely. Transcript Pad and Trial Pad too for trials. It's so easy. It's so intuitive. It's great software. And luckily for me, it doesn't take a genius to operate, because I'm certainly not one, especially when it comes to technology. And it's super easy, very effective. And we use it for all our trials. Yeah,
same. It's awesome. And I highly recommend it. All right. Well, thanks, Matt. I think this has been a fantastic first episode as we're, suffering through life in coronavirus. So thank you guys for listening. I'm John Risvold.
I'm Matt Heimlich.
And until next time, we're on trial.